My name is Cecilia Githaiga. I'm a legal practitioner. I have been in practice for 19 years now, and my areas of practice have been mixed, but I would say that the most prevalent area of practice for me is environment, natural resource, and policy and governance of the same at both local, national, and international. So it has been quite the experience.
Okay. So today we want to talk about environment and climate change. And therefore, first and foremost, we would like to understand what are the key environmental laws and policies that are currently being enforced in Kenya?
Um, First of all, I would like to say that we have very many laws and policies governing environmental law. It's a whole system, and it doesn't just lie in one sector. It covers multiple sectors, and that's why we have so many laws and policies dealing with environment. So maybe I'll just speak about a few key ones, starting with MCA. And the reason why MCA was put in place is because there was this discussion at the international level where Agenda 21 was mooted. And out of Agenda 21, MCA was born. And this was good at that time because we had like 77 statutes covering different sectors and different areas on management of the environment. So what MCA came to do is be the framework law within which the environmental sector would be managed, to advance sustainable development. So that was really interesting. The act was enacted in 1999. And since then, the change that has happened is that we have had now several laws being amended, and then we have the Constitution of 2010. So in terms of advancement, we are making progress. I want to believe we are making progress. And what I want to mention is that besides MCA, because MCA doesn't just operate on its own, yeah, I mentioned it's a framework law. There is also the county laws, under the physical planning space and land use space. And then we also have the County Government Act. We also have Wildlife Act. We have Forest Act. They're called Forest Management and Conservation, Forest Conservation and Management Act, Wildlife Conservation and Management Act. And then we still have others such as Seeds and Plant Varieties Act and National Biosafety. And what you will notice is that all these laws are managed, are housed in different institutions, but they all have to coordinate so that we can have a harmonious implementation of environmental laws. So just to mention that what I'm saying is that we have those ones which directly impact the environment, like the Constitution and MCA. And under MCA, you'll find different regulations. And then there are those other laws which are managed by institutions which are called lead agencies under MCA. So MCA has to coordinate with these other institutions to be able to uh, uh, engage in a holistic way environmental matters. So every time you submit an EIA report, it has to be sent to the other lead agencies and other stakeholders. Remember, there's also water, any other sector you can imagine. There's Water and the Water Resources Act. Which other one do you consider key for our discussion? I think let's just go with that for now.
Okay.
Yeah.
And I have to ask two questions here. So when we talk about environment, do we classify or we do environment as a whole? I've heard you talk about water and sanitation. I have heard you talk about wildlife conservation. How do we classify all these things so that we can have different laws governing each? Or how do we classify environment simply?
For me, environment is a system-wide discussion. I think we may not be able to discuss either of them separately if we are going to achieve system-wide change or management, because you'll find that if you're dealing with forests, for example, Some forests have water towers, and others have, rivers and lakes that are important for us, or they are the sources actually. And again, you remember we have the Water Towers Agency, right? So we 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 also have different species, plants and animals within that forest. So again, the issue of wildlife comes in, and species protection is also an issue in Kenya. So the regulation of it, and the regulation also has a myriad of laws, including those on research and how that research is governed, and who can access our resources. You see, it's a whole interaction. So maybe we might not separate issues environment, but rather look at them holistically, whether at policy, law, and implementation.
And again, Wakili, how do we harmonize all these laws? Are they harmonized at the national level or at the county level? Because I believe these people do not just operate. They don't just wake up, form laws, and operate independently. How are they harmonized?
Laws are supposed to be harmonized at the policy level. And the beauty about our laws and policies in Kenya is that we are governed by a constitution which came after MCA had already been in operation. So ideally, what is supposed to happen is that all of us are supposed to look at our implementation of environmental law, just like any other law, of our environmental laws within the purview of the Constitution, and make sure that whatever we do is in harmony with the Constitution. And what are these constitutional imperatives? We have to ensure that there's good governance, yeah, and Article 10 and Article 2 and Article 42 and 69. 69 is the one that is mostly on environmental governance. So even in terms of enforcement, there's Article 70. So what we have to do is borrow from the Constitution, going to the policy level, at national level, and also making sure that whatever we do at national level is also coordinated with the county level actions. The Constitution provides how the two levels of government work, and the two levels of governance also have a mechanism for coordination, and they also have a mechanism for transfer of functions, or having like regional authorities for purposes of those areas where we have cross-cutting issues that need to be sorted out, or engaged, that engage different stakeholders from across counties. So the Constitution was actually a very good thing for environmental governance, and it guarantees the right to a clean and healthy environment, and Article 42. So that's where we start.
Okay. Let's talk about the National Environment Management Authority, NEMA. What role does it play in enforcing environment laws? And again, under what policy is it formulated?
NEMA, now the short form of the National Environment Management Authorities, NEMA, was the body that was put in place in the process of governance of these environmental laws and policies and everything environment we have in the country. So their first and prevalent role would be coordination. And that is why I mentioned earlier that we have to have a system-wide effort in governance of environmental law, policy, and implementation. And now I go to regulation as well, because even when you're regulating, you will have to check each and every aspect of these environmental issues across sectors. As far as all the laws are concerned, if they have something touching on environment, you also have to check that. And how do you do that? A member of the public or a developer, that's what they're called in the Act, a developer would engage an EI expert, environmental impact assessment expert, and this expert is also one who must have been registered and given a certificate to practice by NEMA. So if they're licensed to practice by NEMA, their standing in this transaction is as advisors to NEMA and as advisors to the developer. Yeah, but remember, they are engaged by the developer. because NEMA will not cover those costs, yeah. But once the EIA report is submitted and NEMA is maybe evaluating it for its merit and all of those items it's supposed to check and confirm, it also sends that report to other agencies, the ones I was mentioning, and many more, depending on the area or ecosystem that is being impacted by the project. And once those agencies are sent those documents, they are supposed to give feedback on their technical parts, and maybe if it's environmental issues concerning wildlife, they would say, if they were objecting, this is just an example, they can say, for example, no, that project may not be good for that area because there are species of importance or species that are endangered that are in that ecosystem, and it would not be good to interfere with them, something like that. So that is one thing. Oh, but it's not in all cases that you submit an EIA. There are other areas where you submit a project summary report. When there are not many environmental issues, or where there is a small impact, lower impact project, but for significant, then there are three categories. One is the low impact, then there's the medium impact, and then the last category is the high impact, where you'd expect more significant impacts of a project on a site, for example. So that's just one way, the EIA. And then the other part is by monitoring. NEMA goes around, is empowered to go around and check and confirm whether everyone is doing what they say they are expected to do in the EIA report, because there's a management plan in that EIA report. And that management plan talks about how you are going to make sure that you mitigate the impacts of the negative impacts on the environment. So NEMA will check the baselines that you presented in the first EIA report against what the situation is as you go along.
Yeah.
So that is in terms of monitoring. They also can do inspection either on their own volition, or they can also just be called in case there's a complaint, or if there is, for example, I think like if there's a hazard, that is known, like an oil spill, they can just come and just, play their part, try to verify what the problem is and things like that. And they can also call for another EIA report to be done. If there are complaints, they can actually ask that the project developer repeat that EIA again, to make sure that, maybe if they miss something, they can pick it up, something like that. So they do issue a license, but they also have rules with respect to that license to ensure that the conditions in that license are adhered to. And so they can also coordinate with other agencies, because some of them have specific functions, and request those agencies maybe to take action, or they can do certain things together to maybe remedy a situation. Like in the case of the oil spill, they can work with the agencies responsible for oil. So that those could be a few of the examples. There could be many more. I don't know how far you want me to go.
I think that is far enough. Yeah, but Wakili, I would like to know then who the description you're giving of NEMA is that they're doing big things, projects, who is in charge of the environment at the grassroots level, where we are passing the waterways, ensuring Mama Mboga there is not littering while selling whatever she's selling. Who is in charge of the environment at this mashinani level? Because I believe environmental hazards begin from chini kabisa,
Yes.
tukiendelea. Yeah, so yeah.
I want to maybe mention that we have instances where we have counties in charge of the areas which they manage, yeah? And, under the devolved system of governance, besides the MCA and the Constitution, which mostly are utilized by everyone, we have the ministries of environment, which are in charge of the policy level decision making, policy making, and giving direction to the country. So the Ministry of Environment really doesn't work alone. Just like NEMA and other agencies, they work in a coordinated function way. So what happens is that when you trickle down to the county, where the law is provided for at national level, whether it's environment, wildlife, whatever it is, you will find that the counties would most likely borrow so that they can harmonize and make their own according to their circumstances. Yeah, but when there is no policy guidance, I have seen some counties make their own law, and so that could be a good thing because at least there is a law governing a resource. Again, there could be challenges where the national level comes later, and then there would be conflict of some sort. But you know what is provided in the Constitution about coordination between the two levels of government is that there is actually a summit which is held, and this is a place where some of these issues like coordination can be sorted out. There is also the Council of Governance. So for me, I think the governance system is there. It allows every person to play its part, and it is very possible to coordinate all these efforts. I also want to mention that in terms of communities found on the ground, we have those ones in the city, Nairobi, Eldoret, recently, Mombasa. Their dynamics are different from the communities in areas like, grasslands or where we have forests. So there the difference comes in.
Yeah.
And if you look at it critically, all of us are responsible for the environment. Yeah. And the Constitution actually provides that all of us are supposed to coordinate under Article 169 to coordinate with the agencies to fulfill the environmental requirements. However, when you go to the communities now living with our communities on the ground, you will find that some are really, really impacted by the impacts to the environment more than others, especially if they rely on the environment for food, water, medicine. So you'll find that if, for example, the environment is not managed properly and climate change takes a toll on us, then most likely some will not have, the bees in the way that they are normally used to having them. So their livelihoods will be altered, or they will not have, the relevant medicine that they need from the flowers and the species that they use. So the environment affects us differently, and we take responsibility for the environment much as I would like to say it's the same. I think it impacts more the people who rely on the land, environment, and the resources coming out of it for day-to-day livelihood. So in terms of responsibility, I think we do owe those people who take care of the environment in our communities much more, because they are the reason why we can even have waters flowing to Nairobi from whichever areas in Kenya. So yeah, that's a different dynamic for them.
And who is tasked with the responsibility of sensitization
Very good question.
of communities? Because I believe the major problem we have as a people or as a country is that people do not really understand what is the importance of conserving the environment.
A very good question you have asked, and I would like to say that in as much as we have provided for public participation under the Constitution and Article 10 to I can't remember the specific one, but public participation is a requirement for good governance. And then public participation is also provided for under Article 69, which deals with environmental matters. So what happens is that MCA and other laws have entrenched public participation. It was there before even the Constitution, but the Constitution made it so critical for us to engage in this process. So that's a good thing. So what that means is that all agencies of government have a role to play in ensuring that there's awareness. In fact, if you look at, I think, all the statutes I have read, they always have a mandate there saying create awareness amongst the functions of the organizations or the agencies that are formed. So awareness creation is cuts across for everyone, because if you are in charge of, let me use something that maybe Kenya has done recently. If you're in charge of climate change, you have to create awareness about climate change, because ideally government is creating the policies, it's making the laws, and it must engage public in making the laws and the policies and such activities, even in designing projects. And what I find is that governments have embraced the idea of public participation. Again, counties also have the same mandate, and in the constitution and according to the constitution and also in the County Government Act, they do have a big role to play in public participation. And it's even good because they are the ones who are, in direct contact with their communities that they are in charge of. And what this means is that public participation must be funded, and funded well, if it's going to reach everyone, to bring everyone up to speed. But besides government, there are other NGOs working in this space, a lot of them, and they're all they're all working in different spaces across the country. Some have different expertise from others, and some really coordinate very well. So they also do create a lot of awareness. In fact, in some spaces, were it not for the NGOs, I think the communities would still be lagging behind.
Yeah.
So that is just something else to note, because they also have their own funding
And
streams.
projects, yeah.
Besides NGO, we also have development organizations and funders who also work in harmony with governments and their stakeholders. So it's a function that many
Cuts
people
across.
have, depending on where they are found, including LSK, considering that I was invited here courtesy of LSK Nairobi branch. They too have a function to create awareness. I mean, if they practice law, they're the ones who would most likely be best placed to create awareness.
Okay. Let's talk about the mandates of the National Environment Tribunal. What does it do?
The tribunal is let's talk about grievance redress mechanism in general.
Okay,
yes,
Sawa.
the tribunal is one of those avenues through which you can seek redress. But before you even get to the tribunal, there's another avenue. You can actually write to NEMA and appeal, and they would consider your written appeal. Say, for example, if they issue a license or maybe deny, you can write to NEMA and they can consider the appeal. Yeah, but nothing stops you from heading to the tribunal straight on, if you think that is your best course of action. And so the tribunal has mandates for different categories of stakeholders and developers. For example, if you have been issued a license, you can go to the tribunal if maybe the conditions imposed do not sit well with your project or with you, the reasons are for you to design. There's also the issue of those cases where NEMA has denied an applicant license. So the two kinds of grievances follow a different pattern. If you have been denied a license, whether or not you have been denied a license or issued a license, in whichever case, you have to appeal within 60 days, right? It's under Section 129 of MCA. Now, there are several reasons why a license could be denied, yeah? The conditions we mentioned, you could also be maybe having an issue of revocation of a license. Remember, I told you NEMA can recall and request you to submit a fresh EIA or maybe make any kind of inquiry, because that's your mandate. Maybe if you're aggrieved by the amount of fees to pay, or if an order has been made against you. By the way, I didn't mention that when NEMA goes to monitor or inspect or during their functions, in terms of on the ground work, they can issue orders. Some of those orders could be closure orders of a facility. It depends on mostly the magnitude. Could be closure, others could be restoration, could be production of the license to NEMA so that they can see if you do not have it on the site. And those orders could be also for improvement. You remember there's a management plan which you're supposed to use and adhere to, and there are conditions to adhere to. So those are, if any one of those orders agrees, you can also go to the tribunal. And then if NEMA refuses to give you a license, and it's usually NEMA and its committees. Sometimes an organization can administratively have a committee to advise it.
Yeah.
If NEMA fails to give you a license, you can again go to the tribunal. Now, what the law says is that under Section 129, 3, once you appeal, that action, if it's construction, for example, is supposed to stop. If it's some other kind of damage to the environment, it is supposed to stop, like automatically. That is now an issue for litigants whenever they have to go to court. So basically, that's one way of addressing these grievances. The other way is by going to the Environment and Land Court. Now, depending on jurisdiction, you can either land in the magistrate court for maybe projects which are not so huge with high impact, or you can go to the ELRC with the same jurisdiction as the High Court.
And Wakili, let me just cut you short
It's
to
okay.
ask how do I determine whether to go to the tribunal or to the lands court?
The tribunal is the specialized court to deal with environmental matters. Normally, that would be the first stop on matters where a license is involved, granted or denied, right? So you can go to the tribunal, and it's not about NEMA only. The tribunal is also in charge of several other statutes, like the one on wildlife and the one on forests and climate change. Yeah, so on environmental matters relating to those specific statutes, you have to approach the tribunal. If it has nothing to do, for example, sometimes there are matters which are across jurisdictions, maybe the county or across counties, or a destruction of an environmental resource that is important to many of us. You can approach the ELC. Now it's up to you and your advocate to decide whether you want to go and file a petition for redress as a constitutional petition, or if you want to go for judicial review to review administrative action of any of the agencies, or if you want to maybe file a suit. It's up to you now. That's something I'm not able to.
Okay.
Yeah. So it depends on the circumstances. And then, of course, once you land in the Environment and Land Court, now at this High Court level, the appeal after that is to the Court of Appeal, and the process follows on. The only thing that I need to mention is that at the ELRC, there's a division between the Environment and Planning Division, and then there is the Land Division, still within the Environment and Land Court. Before last year, it was just one court. I think these regulations were last year. I can't recall the date, but I can check. So there's practice directions that were published by the court, and they helped because they helped separate the environmental matters, environment and planning matters, from the land matters, which makes it easier to choose which avenue you want to follow. And because environmental matters sometimes have urgencies, like in some cases, people face the risk of death. A building is likely to collapse, for example. So they have different kinds of urgencies, and they have dynamics for handling that may not necessarily be the same as those ones on land. So that was an interesting development. And just to mention that in terms of locus and Article 70, any person can institute a claim in court. Yeah, so In our case, locus standi is giving us a wide berth to approach court for any matter on behalf of people. But you know, if you have to institute on behalf of people, you have to also get their consent.
Yeah.
But also, it's also great to know that you can actually go to court and complain about climate change, for example. Yeah.
Yeah. Okay. And I see time is not on our side.
Yeah.
And you'll surely be back because we have a lot to talk about. But let us just talk about briefly the challenges that are facing environmental law in Kenya and environmental laws enforcement in Kenya.
I think the challenge with environmental laws is that even with the not with the harmonization, even with the framework environmental law, MCA, we still continued making other laws, not because we had fun in making other laws, but because they are necessitated by new developments or emerging issues. Climate change, for example, is also a framework law, and then we now have a new agency on nuclear. Do you understand? So it's a developing area that keeps developing, and we may not be able to avoid it. So what we have is also multitude of flaws governing environment. I can happily say that at least there is harmony amongst those ones in most cases. Um, the, the challenge could be that if each agency is supposed to issue a license and a permit, sometimes it can be too much, and sometimes people can take advantage in between.